Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we have an early stream in addition to a late stream that is still happening. The late stream, of course, is with Accursed Farms. We're going to be talking about games as a service and the legal, I guess, implications of games as a service and the conceptual issues with it and all of that stuff. But now, we have, sorry, you caught me at some snack between lunch and dinner, whatever it is. We have some documents that dropped yesterday, and we have a fresh document that dropped just a little bit ago, and it is a bit perplexing and confusing. So I wanted to talk to you about it. Tell you what I think happened, tell you what it means. It's very, very interesting. Very, very interesting stuff happening. So we're gonna do this. I've briefly addressed these motions to quash on my show yesterday with Razor Fist. Great show, by the way. If you have several hours, go check it out. I also briefly addressed them on a Twitch stream last night, following it with a little bit more depth and dedication. But today we're gonna always go deeper or whatever. We're gonna do it a little bit deeper today. What is happening? We're gonna go a little bit deeper on these today and go through the documents. They're very similar for Toye and Rial, so I've got them both, but we're probably only gonna go through one of them super in depth and then note for any changes in the other one. But I want to break these down. I know people are asking a lot of questions. People are speculating about this. They're kind of getting some things incorrect. Although I'm not throwing shade on anyone. Don't make that mistake. They're guessing at motivations, and a lot of their guesses are probably true. And there's been a little bit more. This new document that dropped adds some intrigue to it, and maybe gets to some of those motivations. So we're gonna talk about that really quickly. And then that's that. So one thing I do want to do, first, a public apology. They say never apologize, but they mean never apologize to a mob. I am publicly apologizing to Tug. Tug was scheduled to stream, I think, at 5 p.m. I didn't know that, and I had no intention of trampling on Tug's. Wait, should I do this like Matt Loader? Hold on, let me. Hi. On May 9th, 2019, I was that umbrella guy, otherwise known as Tug on the internet. The guy who says, hey there. He was scheduled to stream at 5 p.m. Central Time. I had some information and documents, and an opening came in my day at 4:45 p.m. Central Time, and I did not, in my haste, I did not check to see if anybody else was streaming, and so I let my emotions and haste get the best of me and scheduled a stream which stepped on the toes of that umbrella guy, and I am truly sorry that this happened, and I would ask the people out there who may see this to go ahead and please forgive my actions, and also please remember to support the littlest umbrella on Indiegogo, as the campaign is closing today, and they have just passed $7,000. And if you could go check it out if you haven't bought it, that'd be good. Good. Again, I apologize and thank you. So there you go. There you go. I actually felt really bad when I found out the Tug was streaming. I didn't know, and I forgive me, buddy. And he and I have talked, and everything's fine. Of course, he has rescheduled his stream and stuff. So there was my public apology for you guys. And yeah, definitely check out The Littlest Umbrella. The Littlest Umbrella on Indiegogo. Let me put the link in the chat, because this is the last day for the case of The Littlest Umbrella. They broke 70,000, which is fantastic, just amazing. And there are 10 hours left, so I know Tug is going to be streaming about that. So do go check that out if you are a person who likes comics or Tug, or even is following this stuff. I'm spamming the chat with it right now. So there you go. Go check that out and support his campaign if you haven't already. Okay. Let's do this. We've got a defendant's motion to quash notice to take the oral and videotape deposition of Ronald Soye with subpoena Ducis Tucum. And don't at me on that Latin pronunciation. I am the least interested person in the world in pronouncing my Latin appropriately, because the fact that lawyers use Latin in general is just pompous holdovers. So, and motion for protective order. Now, this protective order, I have to be clear, because there seems to be some confusion coming from the brain trust over at Pretty Ugly Little Liars. Let me show you what I mean. Here we go. Let's get the brain trust on screen. First of all, not the bees. The fact that Beard Boy wants to interrogate Monica and Ron personally at his own office is suspect. First of all, I believe that the Beard has said that the Amazons will be doing the depositions. So they missed that boat. But maybe, I mean, there's nothing set in stone. Ty could certainly do them. Does he think he's a effing police officer? Nobody should be subject to interrogation without probable cause, especially by someone who doesn't have the authority. This is deposition, dummy. This is deposition. It's part of the discovery process in every civil case. He literally has the authority. And depositions, you have more authority than you do in interrogations. What are you talking about? How are you this stupid? A deposition isn't a police interrogation. There's no police case, you dumb B-word. There's no police case. None of you ever filed one. You never thought to file. You never went to the police. No one ever went to the police. You know why no one went to the police? There's a real simple answer. 'Cause it didn't happen. It didn't happen. At least not the way they're selling it now. So there is no, this is deposition. You have a right to depose the opposing party and any relevant witness. I can't believe the absolute dearth of intelligence that exists on Pull. It's amazing. So then Senpai, oh wait, ugh, Rekieta makes my skin crawl. Well, I have that effect on lots of people. And so does this guy. They clearly don't care about ethics in the case. Depositions are part of it. Get sued so you'll know that you'll be deposed, and scream about an ethics violation for trying to just do what normal discovery is. See how you go, see how far that gets you in front of a judge. They only care about trying to win forcefully. That's true. That's true. That's 100% true. Oh my God. Here we go. Senpai trash. They name themselves. To be fair, they name themselves. What is great is that you know they're going to go against a restraining order. There isn't a restraining order. Even the request for a protective order isn't a restraining order. It's a request for protection from the notice deposition date. So they notice them to be deposed on the 13th for 14th or 15th, whatever it is. They notice him to be deposed on that day. They're just asking the court to quash the notice. Quash sounds like squash. Get rid of, remove, invalidate. And to issue a protective order stating that they can't be deposed on that day, so you simply can't notice them again. Excuse me. I was defeated by spiciness. So they simply can't send another notice the next day for the same date. If that makes sense. So the quashing the notice gets rid of just the notice. It doesn't invalidate the day as a deposition day. The request for protective order goes hand in hand because it protects you from being noticed again for the same day. That's all. It's not a restraining order, you idiot. No, Vic hasn't harassed or done anything to anybody that would merit a restraining order. Neither has Ty. So there's no restraining order in place. Plus, if you could just file for a restraining order frivolously to get out of deposition, well, no one would ever be deposed and every lawyer would have 10 million restraining orders against them at all times. It doesn't work that way. It's not how you get a restraining order. Literally the dumbest takes. I mean, they for some reason think they are invincible. No, these are the rules of civil procedure. Just means jail time for them if they do. No, see, if you can't force someone, they can't teleport Toye into the office. Okay, so let's work this out. Let's noodle this one out with Pull. They quash the notice. They get a restraining order protecting Ron Toye from the mean interrogation of Ty. Okay. What? How does he violate that? How does he forcefully teleport Ron Toye into his office a la Star Trek to be deposed against the restraining order so he goes to jail? How does that work? How does that work, you stupid person? What world do you live on where you like you just don't have the mild amount of thought process required to figure out that that's an impossible solution? Oh, he's gonna violate the restraining order. What, is he gonna kidnap him? He's gonna lure Toye out with some soy pops. Be like, here, come into my van. I got these soy rings for you in my van. A little Toye, come over here, little Toye. Do you like the soy rings? Just let me open the van door. Get in, bag him, and bring him to the office for deposition. What? Where do these people live? I don't get it. Okay. Sorry. Focus. Razor focused. Now comes Toye for the first time and requests this court to quash a notice of deposition and issue a protective order in connection therewith, and shows the following in support of. On or about May 3rd, defendant was served with a notice of deposition to take oral and videotape deposition of Ronald Toye with subpoena Ducis Tecum attached herein and incorporated by reference as Exhibit A, and referred to in this motion as the notice of deposition in this matter to occur on May 14th, 2019, beginning at 9 a.m. at the law offices of plaintiff's attorney. Blah, blah. Defendant requests that the court quash notice of deposition, issue a protective order for the reasons set forth herein. Motion is filed within 3 business days after service of the notice of deposition. Therefore, the deposition is automatically stayed until this motion can be determined per Texas Rule of Civil Procedure. Very true. Very true. And up till now, there's no problems with this document. No problems at all. You have every right to quash a notice of deposition. All right? Defendant's objection notice of deposition as follows. Deposition was unilaterally noticed without confirmation of defendant's counsel with less than a 2-week notice and without sufficient advance notice of the deposition. There's no law in Texas, no rule of civil procedure that says less than 2 weeks is some sort of requirement. That's a made up part of the rules of civil procedure. Without sufficient advance notice of the deposition, there's no requirement to give advance notice of the deposition. And interestingly, there is a complete lack of requirement for notice of confirmation or for confirmation of the dates with defendant's counsel. Interestingly enough, Vic was noticed, and I've confirmed this with Ty. Vic was noticed by Casey Eric without conferring with Ty, without confirmation of Ty, and without sufficient advance notice of the deposition. There was no advance notice that they were gonna there's no advance of the notice, because that's what they've got to be going here. And so this 2-week requirement thing, all of this is exactly what he did. He just set a little bit longer date. Why did he set a longer date? The long story short is they're trying to pull a fast one, depose Vic, not have Monica and Ron deposed, and to file a TCPA motion, which would stay discovery for 90 days automatically. That's what they're trying to do. They're trying to do this. It seems like, and this will become more and more apparent as we go on, it seems like Casey told his clients that they would not have to be deposed, would not have to testify. They would get Vic's deposition, they would get the stay, and they would, my guess is, publicly post selectively edited deposition of Vic Mignogna. Because they're going to try and say he's apologizing, he's admitting, he's doing all these things, all of this stuff. That's what they're going to try to say, is my guess. All right, or what they're trying to do, and probably what he told his clients that they would do. Then Ty went ahead and noticed his clients for deposition earlier. Okay, now freaking out a bit. Defendant objects to the date and time of the proposed deposition. Why? Defendants object to the place of taking the proposed deposition. Why? On what grounds? What grounds are you opposing or objecting to the date and time, and what grounds are you objecting to the proposed deposition place? There's no reason you can't be deposed in Tyler at the offices of Beard, Harris, Bullock, and Hughes. No reason. But, you know, propose an alternative. All right, here we go. There's couple $20 chats. I want to make sure and handle those as they come in, for sure. Bob the Troll King says, first, also, if you aren't drunk yet, I'll be very disappointed. I don't drink in the middle of the day, usually. I tend not to because I might have to drive my kids somewhere. Shocker. Shocker. I'm not, what am I, Kevin Landau driving around all liquored up? No. Mithrin Emmer says, pull are morons. They have no clue how civil cases work. They keep confusing them with criminal cases. So much stupid on one website. It's really a bit much. Sniper Fox says, I now perform my charge in fealty to the God Emperor. By the grace of the Golden Throne, I declare exterminatus upon Kick Vic. I hereby sign the death warrant of the movement, and consign their Twitter accounts to oblivion. The Emperor protects. Very good. And that umbrella guy has also released his scripted reply. He says, hey there, this is my scripted reply. I commend Nick on his bravery and admitting his terrible assault. We will cancel the knife fight at dawn. Whew. Good thing. Thank you, Tug, for providing that scripted response. Very, very helpful to everybody who is just catching up. All right. Let's see. Furthermore, pursuant to an email communication sent by Ty Beard to defendant's attorney, plaintiff has withdrawn the subpoena ducis tecum and his discovery requests, included in his notice of deposition at this time. Yeah. So why'd you respond to them if he withdrew them? But that's not withdrawing the notice of deposition. That's just withdrawing the subpoena. So, there you go. A trial court has broad discretion to protect a party with a protective order. Defendant asks the courts to exercise its discretion and grant a protective order because it is necessary to protect defendant from undue burden, unnecessary expense, harassment, annoyance, and/or invasion of personal, constitutional, or property rights. That's, again, referring to the deposition date in question. That's it. This doesn't, if they get that protective order, it doesn't protect them from deposition. Vic has a right to a deposition of these people. They're party to the case. There isn't an excuse or an exit from deposition. There's only an exit from a particular date, place, and time. That's fine. But for people that think that this is some sort of protective order from any deposition, that's just a misunderstanding of the rules. So I hope that is clarified for you guys, that part of the rules, this is just how you go about squishing it. Correction, this is one way to go about squishing it. The really easy way to go about squishing it is to just go ahead and talk to opposing counsel. That's how you would do it. You talk to opposing counsel, you'd work out the appropriate dates, and you'd notice for deposition on the appropriate dates. Say, hey, okay, give me your schedule. And then they give you the schedule. And then you say, okay, we'll do it. This match is here. This match is here. Let's do it these days. And you tend to only notice without conferring with opposing counsel if, one, you're trying to do something. And something could be scummy and something could be not scummy. Right? Maybe you just want to get the case moving along. Two, the other possibility is that the other counsel isn't conferring with you or something, so you just have to notice them. You're like, I'm asking for dates. What do you think happened? I mean, I'll tell you flat out, Casey noticed Vic without conferring with Ty. But Casey noticed Vic first. You think they had a conversation about appropriate dates for Monica and Ron? I mean, I'm guessing there was a pretty significant lag time between those notices. So why would Ty have to notice without giving you advance warning? I can't think of it. What would it be? Would it be because he filed he noticed Vic, and then he decided to wait out the 3-day rule for quashing a notice to deposition and not provide dates to Ty within 3 days? I wonder if that was the plan. Because it makes it a little tougher to quash depositions after that 3 days. Not impossible, but a little bit tougher. So if you just don't give dates and then you refuse every other date that's presented, oh, well, you know, I guess they're just dead and they'll be resurrected on the date of deposition of Vic. So you can't depose them before then. Maybe that's their plan. It's a stupid plan. It kind of looks like discovery abuse if you're not conferring with opposing counsel and giving them a list of dates. But I don't know. Maybe that didn't happen. Maybe Ty's just a jerk. Could be. Could be. Maybe Ty's a jerk by returning the courtesy of not informing them what happened. I don't know. I'm just giving you a possible reason why Ty might have noticed Monica and Ron something like 4 days after Vic was noticed. Maybe. Anyway, yeah, so there's that. Pursuant to Rule 191.2 of Texas Rules of Civil Procedure, efforts to resolve these matters without court intervention were attempted, as evidenced by the certificate of conference included herein. Oh, were they attempted? That'll be interesting. Defendant requests the court quash the above described notice of deposition. Protective order be entered and other relief, blah, blah, blah. I certify that on May 3rd, 2019, I contacted plaintiff counsel and requested he withdraw his notices of deposition served on defendants. Plaintiff's counsel responded and stipulated that the subpoena ducis tecum and document requests therein were inadvertently included with the deposition notices, but did not agree to withdraw the notice of deposition. As of the date of this motion, plaintiff has not withdrawn the notices of deposition, and therefore this motion is presented to the court for determination. Sounds like a lot of effort on that conference. A lot of effort to remove that. You know how most people resolve this very simply. Remove them. Okay, what date can I do it? This date. Removed. Let's do it that date. Hypothetically, how do you think that conversation went? Remove them. Okay, what date can we do them? I'll get back to you. May 3rd, May 7th. Let's see. Yeah, so this is within their three business days, I think it is, right? May 3rd to May 7th. Yeah, 3rd is a Friday. 6th, 7th. Technically, could have done it probably on the 8th. They could have filed this motion, but they did it on the 7th. Either way, they still had a day left. They still had a day left that they could have discussed this with Ty. It looks like it, because if it was filed on the 3rd, it'd be 3 business days. 3rd being Friday, you'd have Monday, Tuesday, Wednesday. But they filed this on Tuesday. There's a lot of infantile hand-wringing going on here. And again, simple solution. Give the dates. Give the dates. What are you leaving out, Casey? What are you leaving out? An upstanding member of the bar. What are you leaving out? All right, Kenshin 891 says Vic Stan's lawyer literally question raped me. Every time I see a beard, I start literally shaking. This is America. Our justice system doesn't believe survivors. This is why we have Dorito in the White House. And Sakaki Onsai says, so what I'm seeing is that Casey, Eric, Monica, and Soy Boy are trying to get information in order to publish it in the court of social media. Ty figured it out and went exterminatus. Sounds like typical Mo Ronica splat. Yeah. It kind of looks that way. You never know exactly what someone's doing, but we can definitely comment on how it looks. Some of this stuff, the certificate of conference stuff, leaving out some pretty crucial parts. I provided alternative dates and Ty refused would have been a really interesting line, right? I provided reasonable alternative dates and Ty refused. Why isn't that in there? Why isn't that in there, Casey? I know if I was trying to convince a judge that they needed to stop a deposition, that I would say, look, I tried to resolve this. Here's my attempts at resolution. I asked him to take him down. He said he wouldn't take him down. I provided alternative dates, and he said he still wouldn't take them down. Even if the alternative dates are like 5 months from now, at least you provide them. Do something. I talked about the unreasonableness of this. I would layer that certificate of conference with some more padding, personally. But he didn't. Why? So now here's the really interesting thing. This whole thing, I'm not going to go through... I'm not going to go through the whole thing. Here's the notice. Here's a notice. Please take notice that at the time, date set forth below, blah, 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 blah. Here's all this stuff. So there's the alternative means of conducting and or recording. And then request for production. That's the subpoena. All right. So time and place, this time at Beard, Harris, Bullock, and Hughes. All right. Casey notes in his motion that Ty withdrew the subpoena. Ty withdraws the subpoena. Why would you then respond to the subpoena with a list of objections? Why would you do this? I mean, I'm betting he billed his clients for work that was unnecessary. Right? Look at this. Look at all this. All these indented paragraphs are his. He's fully indented. Overly broad and not reasonably limited. First of all, these are all weak objections. Very weak objections to these requests. And if they try and pull this on the main discovery document, or the main document production requests, they're going to have a real problem with this. They're going to have a real problem with this. But why respond? They're withdrawn. You have an email, apparently, according to you, you have an email from opposing counsel saying they're withdrawn. What's he going to do? Say he didn't send the email that you have? What plan is that? Who would do that? That'd be weird. All you have to do is just not respond to the subpoena. Plus, I mean, if you get it quashed anyway. So what did he do here? Did he just run up the bill? It kind of looks like it. But that's me. I don't know. Hope Monica and Ron are still happy about not crowdfunding their defense. Same thing. This is the exact same document. Yeah. Pursuant to an email sent by Ty Beard on this date, May 5th at 11:04 a.m., plaintiff has withdrawn the subpoena ducis tecum and his discovery request included in his notices of deposition at this time. So, why did you take it upon yourself to spend your client's money? I mean, maybe you did it for free, responding to a withdrawn subpoena. Why? That doesn't make any sense. What? I don't know. Please read all 15 points? No way. What a waste. You've seen these. I'll give you an idea. You've seen them. What is that? My computer just beeped. I don't know what on earth was beeping. Just a second. Very weird. Very weird. But you've seen these, okay? So, all documents and communications referencing plaintiff or defendants from June 1st, 2017 to present. Plaintiffs between the dates you first met plaintiff and the present. All documents for a third party that relate to your allegations that plaintiff is a predator as you have alleged. all these things, they're very similar to the requests for document production that are in the whatchamacallit, in the initial thing. But it doesn't matter because they were withdrawn. There's no reason to respond to any of them, much less all of them. Kenshin891 says somebody else requested a basic civics lesson, RE Marbury versus Madison for Tug et al. There you go. There you go. So anyway, I don't want to sit and focus on these too hard. The long and short story of these two motions to quash is that in a vacuum, a motion to quash a notice of deposition is not in any way underhanded. The interesting stuff is in the details. It's between the lines. Why are you filing a motion rather than sorting it out with opposing counsel? Are we to believe that you provided alternative dates and that Ty didn't cooperate with them? Maybe that's what he wants us to believe. I have a hard time believing that. Or are you trying, Casey, Pumpkin, are you trying to depose Vic, then file a TCPA notice to stay discovery for 90 days so your clients can continue their relentless smear campaign? Is that what's happened here? I mean, you wouldn't be doing that. You wouldn't be abusing the discovery rules to do that, would you? That'd be weird. That doesn't seem like something a super lawyer would do. So I don't believe that Casey would do that. I don't believe that Casey would avoid sending, some alternative dates. That seems a bit beyond the pale. Or at least maybe I believed that. Right now I'm not sure what to believe because a new document came out today. I think I'm the first person who saw it. Some of you may have seen it. I don't know if Kiwi Farms picked it up. Last I checked, they had not. But I've got a new document today. Here's some weird questions about it. Let's talk about it. Let's talk about them. This is a letter from Beard Harris, Bullock and Hughes. It was filed in Tarrant County. It was filed today at 3:12 p.m. Okay. Little weird to see a correspondence to an alternative counsel or to the opposing counsel filed by e-service and email. Here's the cause. It says, now I've skimmed through this. We're going to read it all. But says, Casey, I received your May 9th, 2019 letter. Well, that's today. So apparently there was a letter from Casey. I'll tell you that letter is not filed. As last I checked anyway, wasn't filed. And so let me look again and just see if anything new has come in. Because it's really weird to have a response letter filed to a letter that I don't see. All right, no, nothing filed at present. All right. Okay, well, let's read it. Let's read it and see what happens. I received your May 9th, 2019 letter. You took 3 pages to obscure your core argument that you were somehow entitled to depose our client first. Whoops. Surely you are aware that no such right exists under Texas law. Allow me to point out several other misrepresentations in your letter. Ooh. That's a... Do you do the beard voice? I'm not going to do the beard voice. No, that's trademarked by the beard himself. Okay. Guys, we may have something really juicy coming in like Just a minute. I may have something extra for you. Oh my goodness. And I'm talking nobody's seen this yet. Nobody's seen this yet. We'll see. We'll see if it comes through. Let's get through this letter because I think we're going to want to get to this next thing. Allow me to point out several other misrepresentations in your letter. And if you haven't retweeted this link, please go out right now and retweet the show link and tell them something juicy this way comes. Because on this stream, I think we're about to have some law in action happening. So if you could make sure you please like the stream, let's push it up into trending. Let's get this out there because this is a gift, so to speak. And it would be great. It would be great to see a few more people see this. So if you want to do that, I think gosh, come on. I'm watching for it. I'm watching for it. I'll read it. I'll check it every page. Several other misrepresentations in your letter. You claim that you conferred with me. That is flatly untrue. Ooh, that's not good. You unilaterally noticed Mr. Mignogna without conferring with me. I then contacted you about the dates, stating I did confer with you about your client's availability is disingenuous at best. Not good. Not good. As I've noted in previous emails to you, the Texas Rules of Civil Procedure do not give you the right to go first with depositions. You can state, you heard me say we will depose Mr. Mignogna first as many times as you want, but that doesn't change the rules. Can you imagine? Can you imagine this petulant little attorney going, we're going to depose him first. We're going to depose him first. We're going to depose him first. And then thinking that that means that they're definitely going to depose him first. That's just flapping in the wind. There's nothing that doesn't mean a thing. We're going to depose him first. We're going to depose first. Can't be deposed. Depose first. Oh, not in the rules. Not in the rules. You also have no right to define the date range in which we may depose your clients. It appears that you may have unwisely advised your clients that somehow they won't be deposed or required to testify. Bad. That's not good advice to clients. Nothing illegal about it. It's just bad choice if that's what happened. If that's what happened. But no, they absolutely get deposed. You complain at great length about the expense your clients incurred because you were forced to file motions to quash and objections to a subpoena that you were already notified to disregard. Man, I wish I could see this other letter. Don't you? Don't you? Man, I bet it's stupid. Forced to file motions to quash and objections to subpoena that you were already notified to disregard. There was no reason to file your motions Tuesday. All you had to do was pick up the phone and call me. Also, the 3-day window ran out on Wednesday, so there was no urgent requirement to file the motion and respond to already withdrawn subpoenas. That's Okay, next. Oh, goodness. You complain that I refuse to withdraw our deposition notices. That is a disingenuous characterization. I asked you again for alternate dates to depose your clients. After 6 days, you continue to refuse to provide those dates. Well then. We consider this discovery abuse and will file the appropriate motions and schedule a hearing on our motions and on your motions. Uh-oh. You refused to agree to a confidentiality agreement in this case. Thank you for the veiled threat to disclose Mr. Mignogna's deposition information. Quote. So here's a snippet apparently from the other letter. Frankly, I assume Mr. Mignogna gave considerable thought to any personal privacy concerns before he filed his lawsuit. Regardless, my clients have considered his request and it is declined. Well, I'm just suggesting that might have been a poor choice. That might have been a poor choice, Mr. Eric. Here's the thing. Your clients, Casey, your client, can I call you Casey? Your clients are the ones who decided to publicly ruin a man's career. Vic has not publicly or privately, to my knowledge, done anything to your clients. Not a thing. So why on earth would a judge grant your client's confidentiality and not Vic? Vic was drug into this. He's the plaintiff because he is the wronged party. So he's a plaintiff asking for protection, the courtesy, not even asking the court at the time, just asking for the courtesy. Again, because it kind of looks like you want to publicly release his deposition during the 90-day discovery stay that you were trying to get under the TCPA. That would be pretty disingenuous of you to do that, especially after refusing confidentiality, when your clients have a history of defamatory conduct, release of private investigation information that they over and over asserted was private and no one had a right to, and they over and over use that to get him removed from conventions, use that to get him removed from his employment, use that to run his name through the mud. I mean, one of your clients, Ron Toye, has tweeted publicly about this investigation over and over again, and then later, only after hiring you and being served, did he say, lol, I didn't know anything about the investigation. Why in God's name does Vic Mignogna not deserve confidentiality in his deposition when your clients have a clear, demonstrated history of using private information against him in the court of public opinion? Disgusting. Your clients are garbage, absolute trash people, and they know it, and I think you know it too. I think you know it too. This statement and your clients' 400 plus defamatory tweets will figure prominently in our motions. We will, of course, issue trial subpoenas and let your clients explain to the court why they should be allowed to continue to defame Mr. Mignogna. Good luck. Good luck. What are you going to say? Your client is unavailable for the motion hearing? Your lurid characterization of our requests as last-minute antics and erratic proposals is ridiculous. You have refused to provide availability dates for your clients for a week now. At some point, we're entitled to demand that you comply with the discovery rules. You've also demanded that we provide dates for your own clients' availability and after a date that you arbitrarily specified. Okay, so that's kind of weirdly worded. Come on, Ty. But let me clarify the sentence, if I may. He's saying provide dates for Monica and Ron that are after our deposition date for Vic Mignogna. Casey is demanding Ty to throw darts at a calendar only after they've deposed Vic, not before. You must provide dates after. Why? What rule? What rule? Cite the rule. They aren't our clients, and as noted, you don't get to decree when we can take depositions. This is true. This is true. Casey, you really should stop these pointless and expensive games and simply confer with me. This is a waste of the court's time and your client's money. Hey, Ronica. Hey, Ronica. How those invoices look? With warmest regards, Ty Beard. Well, that's nice. Nice little send off. Okay. Okay. 1 second here. Let's see. I'm being told that I am allowed to say something here. Just a second. Trial subpoenas go out in the morning, and they will get hearings set. Have fun explaining to the court why opposing counsel isn't entitled to a motion hearing, which he is, on your motion. Play stupid games, win stupid prizes. At a motion hearing, the parties can be called as witnesses, which means that Toye Rial can be called to the stand to testify, one, why they're not providing dates for depositions. They get to testify just why they get to go first on deposition. They get to testify. What else do they get to testify? Oh, they'll probably get asked about some of those defamatory tweets. I'm telling you, this would be a nightmare to deal with if it goes. This would be a nightmare to deal with. Mimcage Art says, did they get this lawyer from a freaking swap meet? I don't think so. I don't think so. I'm being told that motions are being filed right now. So I'm waiting. If they get filed in the next couple minutes here, I'll be able to pull the motion down and go through it. So it all depends on how long the filings take, plus how long the how long the processing takes on Texas to go ahead and do that. I'm hoping those documents do come down. If they do while we're on stream here, I will pull them up. I'll pull them up and we'll talk about it. But motions are being filed right now. This is imagine, and I don't know if this happened, right? Speculation. Imagine going ahead and telling your clients, no, we'll get him deposed. We'll go ahead and get that deposition for you. And then what? Was it going to get leaked to Anime News Network? Were they just going to somehow acquire the deposition of Vic Mignogna, right? Like, I mean, how would that happen? That type of stuff doesn't happen. Like, internal investigations that are private and confidential don't get leaked. So how would a deposition get leaked, right? That wasn't going to happen. A Vic Mignogna to Anime News Network, to IO9, to Beth Elderkin. Mars Girl, even though I'm pretty sure she's illiterate, would probably get it. Oh wait, it'd be videotaped, so that'd be good for her. These people would miraculously get a hold of this and be allowed to run a smear campaign for the next 90 days. Imagine telling your clients, look, I'm going to get you that tape. We'll be able to run that for 90 days. They won't be able to say a word. We'll have them on defense. And then imagine screwing it up this bad. It's delicious. All right, let me do some of these chats here. Anthony Sear says early and celibate. FTM guy says object to form. Nunya Biz says early and asexual. NGE fan 76 says holy crap, Boomer is streaming while the East Coast Daywalker is awake. Valgarant says, are we shouting? I want to join. He said that twice actually. Jay Moore says, can you be late and gay if stream is early and day? Yes. Texan 83 says loves him some Linner. Yeah. Linner. Epicness 777 says, please hit the fattest yeet of all time. Yeet. Guns Down in Ale says, did you see Pro Jared lost 60,000 subs in one night? No, I didn't, but I also don't, until yesterday, didn't even know who Pro Jared was. Ryan Murphy says, here's my free YouTube red chat, so I don't forget. Thank you so much. Swarm069 says, dun dun dun. Another one bites the dust. Pro Jared, another male feminist being exposed as the garbage bag he is. Reset the clock, people. And your stream came early today, Nick. Haha, innuendo. Thank you. Keck7 Go says, shout out to my Bay Books. My Bay Books. I know you can do it. FTM guy, thanks for the donations. DCV Titan says, you got these pretty fast. Did you have Mars Girl pick them up in Texas and drop them off for you? I mean, it's not like she'd have to leave the couch. Yeah, she just reached. Damian Ridge says, Vic Kickham is coming. Hero says, why all these leftist SJW types seem so seemingly incompetent when it comes to hiring legal counsel? Some of the choices have been bafflingly odd. Casey on the surface seems like a good choice. He really does. This is, these are weird. These are weird moves on his part. And I can only assume that maybe it's because he's underestimating Ty, or because his clients are lunatics and he's just working with what he's got. Both are real possible. Both are really possible. Let's see. Kakalo Tuzaru says, hey Nick, would you do a full Phoenix cosplay for the next session? Like wear white shirt, crimson tie, and blue jacket. I know you said you don't usually like wearing a suit, but for the fans, I'll think about it. The Artsy Tuber says, Nick, please check Twitter DM, package error, UPS sucks. Okay. I will do that. I will do that. Let's see. Okay. That's weird. They're supposed to deliver it there. I'll look into it. I'll look into it. That's frustrating. Magnus Genesis says, that moment when you laugh so hard you start crying and coughing. Yeah, I know that one. FTM guy says, I work at like 6 a.m. so I always listen the next day at work. Had to take advantage to say hi live for once. God bless, Nick. Keep up the great content. Thank you. Wesley Reed says, here's to Nicky Rackets. Watching your vids helped me turn my life around and be a better man. Now that I'm out of the gutter, let's share in the spoils. Hey! Happy to hear that, buddy. DCV Titan says, if I had to choose between listing what Poll knows and doesn't know, I'd make a full list of what they know because I wouldn't have to write anything. Tiny Kitsune, thank you for the donation. Same with the Iceberg Man. Vanish Mantle 4, thank you for the donations. Mr. Michael Law 2011, thank you for the donation. Sniper Fox, I read that one. M says, depositions are now ruled unethical. Bangs gavel. Killer Critic says, how brave of Ron Soye. He lives on planet Idiot. Keck7 Go says, did you notice Ty's response to Monica? I sent it. What? Hold on. Let's see. Where are we? Oh, yep. I got that. We read through that. Thanks. I'm just behind. Thank you, Keck. Let's see. Nick's adult beard says it's good to be back. Isaiah Manolo, thank you for the donation. Karite Sumatai says, Nikki, join new project 2 today. Discord link me, please. Already emailed. It's under my real name, so no docs. Oh, you're doxed. Also, Nico Para, let's play when? I don't know about that last one. Ron Toye. Oh, hey, Ron. On the chat says, I will not be deposed against my will. Smiley, 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 smiley. Solid Carrot says, I'm so lucky to have finally caught stream off the clock. I can finally have a drink. I know it's the middle of the day, but knock one back with me. I can't, buddy. I'm sorry. I'm going to have to drive right after this stream. I just can't. I can't do that. Dan Brooks says, a donation. Thank you. Cutie Honey, thank you for the donation. Nick's Adult Beard says, Nick, you owe me $30 for coercing me into purchasing Ace Attorney. How shall I be collecting? Don't make me hire you to go after you. Justice will be served. Well, you may have to email me to go after me. Paragon 117-2000 says, will you be giving your thoughts on the conclusion to Hambly versus Loader? I will. I did a little bit yesterday. I'm going to do a video on it. It might come out tomorrow early in the day. I'm really trying. I've got a lot going on today, getting ready for my trip. So sorry. Working on it. Joshua Durbin says, is the lawyer Ron Soye's alternate personality? It's kind of looking like that, isn't it? Oh my goodness. Paul Godin says, I just received my household goods from the movers. Thanks for streaming super early to provide me entertainment while unpacking. Well, thank you. Thank you. I will. Oh, guys, I got a quote from Ty. To share with you on the stream here. Are you ready for this? I'm authorized to say. Quote from Ty. Nothing screams, I have a weak case louder than starting chicken shit discovery squabbles at the beginning of a case. So, there you go. Ty, the beard doesn't sound super happy with how this is being pushed through and how they're having to deal with this nonsense. So some choice words on that one. A couple more here. We've got E. Malachi says, oh wait, I already read that. Come on. Don't do that to me. Real Spider Phantom says, if the night fight isn't on anymore, anime it, please. Night of Hopex says, in case you missed my follow-up, I had heard a much different story, not just about evidence not being admitted against Michael Jackson, but what the evidence actually was than what you discussed last night. That there's been some exaggeration, I guess. Thanks for the info. Yeah, and the interesting thing is you can go check out everything for yourself. The FBI has put all of that information out. Don't take my word for it. I am not well researched. I would say Razorfist is well researched on it, but even he said he's not an expert. Go look. I mean, you can go read all this stuff yourself. That's the best part. Kenshin891 says, Vic Stan lawyer. Oh, wait, I read that one. Dang it. Come on. Kenneth Robertson says, explain Marbury versus Madison to Tug and audience. Marbury versus Madison is where the Supreme Court stepped in and decided to take power of judicial review. The power of judicial review, power to declare a law or an act of government unconstitutional is not in Article 3 of the Constitution. It was created in Marbury versus Madison. So that's what Marbury is. That is what Marbury versus Madison is. And I think it's a bad decision. Kara Pappas says, who is it for? Well, it's for the fans. It's for the fans. Mithrin Emmer says, FYI, so far as my research to this point, looking at Texas and federal decisions, there may be a really good argument that Vic should not be considered a limited public figure. Just started reading those cases, but promising. Oh yeah, keep me updated on that, buddy. That would be great. Let's see. Mithrin Emmer says, I want a PO because reasons. Oh, protective order. Really? Looks like Casey is doing what his client wants, but isn't happy about it. A monk stripper. Thank you for the donation. Kenshin891. Oh, somebody else requested basic civics lesson, R.E. Marbury versus Madison. Okay, now that makes sense with the Kenneth Robertson tweet. But that's basics. I have a full video on Marbury versus Madison. It's a very old one on my channel. But if you type in Rekieta Law and Marbury versus Madison, you'll find it. Al Valentin says, didn't Ron publicly state multiple times that they want this, look forward to it, and want the truth to come out? Bunch of cowards trying to hide now. Yeah, well, I think you failed to consider all the smiley faces in those tweets. FTM guy says, Nick's PC beeps, confirms it, also objects to form. Hated 7DTD. I feel like I'm missing something. Did you talk about the deposition dates on yesterday's stream? A little bit, yes. Is this the only... It is the only one I didn't watch yet. Yes. Yes. I've not heard anything about the dates, who is first or last. I talked about them a little bit yesterday, but yeah, the long and short is they noticed Vic for the end of May, and Ty attempted to notice Toye and Rial for the dates after, so the 14th and 15th, the dates after their answers due, and then Casey lost his mind. TLJ Screwjob says, told my therapist about the Vic situation, namely the Jelly Bean incident, and how there's 20 plus years of accusations. About the Jelly Bean incident, she said, that doesn't sound sexual at all. It sounds like a harmless joke. Well, that's because she sounds like a normal person. She also had no answer for, quote, if Funimation had 100% proof that Vic is a harasser of some kind, why wait to be sued to show it? She was very neutral about it, very professional. Yeah, who knows what's going on with Funimation here. But I think Funimation should probably take notes on exactly who's on their side of this right now. These gentle flowers are gently dragging Funimation into litigation that is unnecessary, expensive, bad for PR and publicity, and is just, it's a gross and net loss for Funimation. Even if they win, they're destroying goodwill with their fan base. They're looking like fools. They're looking like they're aligning with lunatics who just can't stop making idiots of themselves. Funimation, you guys really should be considering how you want this to play. There's a simple play for Funimation, right? I think this is obvious to everybody watching. The simple play for Funimation is, oh dear God, what do we do to get out of this and get these people thrown under the bus? Literally, proactively pick them up, throw them as fast as you can under a bus. Proverbial bus, metaphorical bus, whatever bus you need. Just not a short bus. You need the full length of bus for this. They should be thrown under the bus immediately, because if you don't, and this goes to trial, there's at least a moderate chance that a jury finds that Toye was acting as agent for Funimation, and Funimation gets joint and several liability on civil conspiracy. I'd say a better than outside chance, a moderate to a good chance. There's one way to squish that, and that's settle it out. Why on earth would you align yourself with, how do I put this politely? People with very warm vests strapped to their body, running, screaming into public places. What are they doing? What are they doing? They're going to detonate everyone around them. And it's happening in real time. You can watch it. And if Funimation isn't seeing it, I don't know what they're thinking. I don't know what they're thinking. But, you know, if it were me, I'd be trying to put this to bed as fast as possible. Because these, the bad allies, so to speak. Quantum Video says, check out Quantum Videos. I have lots of Skyrim and video game content, new videos daily, and lots of faith-based content. Check that out. Kevin C. and Jake, thank you so much for the donations. Octorian says, Battleship Yamato Rising. There you go. That umbrella guy says, Beard Harris and Flamethrower. Dark Gun 22 says, had to donate after watching your stream featuring the complete catastrophe that is Shane. It was so entertaining, I'm surprised Netflix hasn't greenlit it for a series. Ricada Law and Poner, anyone. Schmidt, such a delightful little imp. How could anyone not like you, Nick? Seriously, people, look at that Poonam. I don't know what that is. Crusader Saracen says, holy poop, the beard does not play FF games. Great stream last night, by the way. Definitely have Razor on again. I'd love to. Razor's great. Razor's great. Jessica Eustace. Jessica Eustace says, when you get snappy at dad and he gets his belt. I think that's describing Ty's letter. I think it's an accurate and apt description. Mithrin Emrys. I read that one. Wait, no. It says, I retract my previous statement. WTF is Casey doing here? This is high-level idiocy. Is stupid contagious or something? Ryan Boggs says, looks like Soye got a soy-blooded lawyer. Joe Lugo says, Lady Gaga is Nick Rekieta in drag. True story. True facts. Ex Varna says, so it's true what they say about lawyers looking more like their clients. We all know it's hard to defend people like Toye and Rial without looking stupid, but a little effort would be appreciated. Mazamonti says, very clever Ty. They acted predictably stupid. Marina Proger says, Tug GoFundMe, check it out. Yes, go check out the GoFundMe or Indiegogo. Tug has an Indiegogo. Texan83 says, don't forget, folks, Casey's law firm has a park named after them. Joe Carroll says, I work for a real estate law firm doing title work / curative. This seems a lot more interesting than my day-to-day, that's for sure. Oh, peace be upon you, good sir. Mimcage Arts says, did they get this lawyer from a freaking swap meet? Oh, I read that one. Patrick Ells says, the beard has a very polite way of telling people to take a long walk off a short pier. G. Casciane says, but Shane advised. The man from Kiwi says, Landau 2. Evil Bunny says, buy Miss Rackets some flowers on chat. Right now? Hold on, we'll see. Chaotic Vic says, Mars Girl's arms are so long. The problem is, we're leaving town. Lady Rackets and I are, so I can't buy her flowers right now because they'll get here while we're gone. But I'll tell you what we're doing, and I'll tell you what it's going towards. That'd be great. I'll do that. Chaotic Vic says, Mars Girl's arms are so long she can slam dunk from the concessions booth. Shout out to my boy Irohe. Mr. Deadman, thanks for the donation. Sakaki Onsai says, motions are going out. Legal middle finger style. Chris Nunez says, good day to you, Nick. Just jumped in. Glass of a Japanese Suntory Hibiki whiskey for a stream I finally see live. How bad will this be for their case going forward? Between this and the Pro Jared dumpster fire, today is a good day. This is great. It's a bad move. A big misstep. Blademaster 1942 says, oh my, that's a spicy meatball and take my money. Quietness says, Funimation sub for the month. Number 3 or 4, I forget. Thank you. I appreciate it. Jessica Eustace says, final form Shaggy voice. Like, how did you beat me? I was deemed strongest man. That's from Ty, laughs and beard. Tom531 Cat says, Nick, they done F up, right? Yeah. Then they done pissed the beard off too? How embarrassing. Right? Right. Eagle Stallion says, did you know all of this is out? The entire documents are available on Reddit, unredacted. So you can go check those out on Reddit. Someone on Reddit must be following along with the filings and keeping those up. Let's see. What else do we have here? Frozen Soul says, free chat, go get them. Oh, I guess I could put that. Hold on. I'll get that Reddit link for people. Oh my goodness. Terrible at this. Terrible at this. Here's the Reddit link that was sent. Here's the Reddit link for those documents. Frozen Soul says free chat. Go get him. Will do. Ron Toye says we get to depose Vic first because my lawyer and Pull said so. Whole bunch of smiley faces. Bryce Cannon says, Nick, thanks for getting the info I requested. R.E. Ties cigar, whiskey, barrel wood incoming. So your gift will be as well. BC, hey, thanks, buddy. Can't wait. Fatal System Error says, for liquor, have fun. Thank you. Eduardo Ramirez says, play Honey Select next time. Big ups, Liquid Richard. Brian Goza, thank you so much. Paul Delaney says, Nick needs some advice. My wife found out I bought $100 of Pyro for a Mill Slim this weekend, and she's absolutely pissed and knows how to hide a body. Well, wear a loose sweatshirt and a phone book. I hear ladies like to stab. Just duct tape phone books around the midsection. Double A says, chances of Ronica Soye writing an ethics complaint against Casey when they lose? Oh gosh, that'd be embarrassing. Zarindu says, say it with me now, lads. Get woke, go broke. Mither Nimris, oh, I read that one. AB says the beard has been feared. Casey Bear Cosplay, thank you. Bunsy the Frog, what great news for a stream that I can catch live after sleeping through the last month of them. Next few weeks will be juicy. I think so. Hold on. Seeing if they're filed yet. We're getting through the chats here. They're not up just yet. Not up just yet. Octorian says, my chats don't count because it's Canuck bucks. It's not my fault. I can't control the exchange rate. I think they do. I read $20 Canadian chats as if they're $20 American chats, even though I know the truth. Brian Goza, thank you. Yukishiro Rai says, the beard sounds like he's ready to Game of Thrones them, and I have a fresh bottle of Kraken rum. Hated 7D7D says, thanks for my very own TLDR. You're welcome. Blink Your Eyes 1400 says, throw them under the bus in Minecraft. Anthony Siebert says, squishy cat. Ricky B, thank you for providing me with entertainment while I do dishes. Thanks for all you do. Are you going to be at Anime Matsuri? Yes. And hosting a panel? Because if you are, I want a non-consensual hug or I'll sue you for my hurt feelings. Just kidding. Sounds good. I don't know how to give you a non-consensual hug at this point. This says, just bought my first Glenlivet today. Thanks for the introduction, Nick. Looking forward to having a few glasses during your streams. Streelock says, snowed on last night. The weather is effed big time. Yeah, me too, buddy. Me too. Ear Juice says, Miss Start, can you give a quick overview of motion? In just a second. Bash Lancet says, I made a remix of your Malice B rant. I bought Fear the Beard patch. Hasn't come yet. Love your work. Keep it up. Everyone is allowed to use it. Vic, kick their butt. Did you see the Wizards of the Coast is being sued? Yes. And I'm hoping to bring Hambly on to talk about that Wizards of the Coast lawsuit. I think he'd be a good resource on that. Fatal System Error says, you need the full length of bus for this. You say new ideas for your merch every day stream or every stream. Thank you. RPG or 90 says, have you ever seen the Alex Jones vid on Michelle Obama? No. If so, what do you think? I think it's hilarious. I haven't seen it, but I know it's hilarious. Bashland says, also a friend of mine wants to hear you say, all hail Blue Whale Krill be unto his name. A Cool Man 229 says, what days will you be at Anime Matsuri? I think all of them. You know what day the panel will be? Not yet. Son of Ultra 7 says, the real name of their lawyer is Ron Zoye. Rocky says, hey Pimpalicious, plug the GoFundMe so we can make sure our boy Vic can go the distance if these clowns want to play games. Yeah, I do want to stress that all this stuff is very expensive. So definitely check out Vic's GoFundMe. It broke 155,000. So let's keep it going. We're right now at something like, let's see. We're at 31 Mars Girl. We're at 31 Mars Girl GoFundMes. Let's get Vic's all the way up to 200. That'd be great. Bamboo Shoot says, oh, whoa, to those who deny reason and reality. Octorian says, ignore that $5 chat. You'll see the one. This one. Okay. Unholy Scavenger says, what happens with the subpoenas withdrawn? Does Soye not have to provide all that was requested? He doesn't have to provide them at deposition. The document requests that were in the original filing are not the subpoenas that were submitted Those were submitted along with the notice of deposition. So they're two separate things. They'll still have to reply to the document production requests that are with the that are out there with the complaints that were filed. Okay. Evil Bunny says, by the way, you really need to stream chapter 3 of Ace Attorney. The parallels with the Vic situation are kind of amazing. I will sometime next week. Maybe I'll start it. Grits McGravy says, Beard Corps of Tarrant County fixes bayonets. Happy Texas noises. Mr. Deadman says, love you, Nick. No homo. Back at you, buddy. Fancy Gusto says, you conquered late and now you move on to Toonami's old time slot. Absolute mad lad. Solo Beverly says, Nick, I just completed my final of my academic career. I'm super excited. Can I ask for congrats? Of course you can. Congrats, Solo Beverly. I get my Associates of Applied Science in IT with 2 certificates. I'm excited. You should be excited. That's great, buddy. Very happy for you. Frank Valaro says, can I sue my wife for throwing away my pee jar? Yes. Jacob, with a very big donation, thank you so much, says, Ty don't need to order an Exterminatus. He is one. Best wishes from the philanthropist. Well, thank you very much, Jacob. I appreciate that. Vanish Mantle 4 says, hey, Nick, thanks for the streams as always. When you get a chance, can you check my game out? The site is creativevirtualmagic.com. Sure. I'll give it a look-see. Failed Senses 7 says, hi, Nick, I sent you an email with a t-shirt idea I have. If you could take a look, love your streams. Been watching since the lawsuit days. I will do that. And finally, Ryan German says, booze for the Boomer God, shekels for the Shield Throne. Sorry, couldn't resist. No, I appreciate it very much. Thank you. All right, guys, I'm looking for the motions. They're not popping up on the filing system. They may be because they're filed after hours. They may not pop up until tomorrow. So I'm trying one more thing here, but it's possible that I won't be able to see them tonight. With that said, I think I should probably end the stream. Do not be surprised if I do an emergency stream later today or tomorrow morning sometime. Don't be surprised. I can't sit around and wait for them because I do have to get ready for my trip. So we'll be doing that. Tonight is, of course, Accursed Farms. Accursed Farms will be on. We'll be talking about games as a service. That's at the normal time, 11 o'clock, 5 hours from now. So feel free to come check that out. Should be a great show. Hits right in the interest of a lot of people, myself included. And we're going to approach it a little differently than Lior and French did. And we'll be having just a good discussion. And yeah, so come check that out. As for this stream, let me go ahead and start the outro music and hit the last couple chats that came in. Here we go. There's that outro music coming in for you guys. And we've got 2 more chats. Cesario JPN says, hey there. Oh, wait, wrong live stream. Make sure you check out Tug's live stream, which I believe is at 7 o'clock. I believe it's at 7 o'clock, so check that out. And then FTM guy says, reading chats before 4 a.m. sounds like stall tactics. It was actually a stall tactic. I was hoping we would see the motion show up in... Oh, come on. You didn't. Guys, I might have to cancel ending the stream. 1 second. One second. Okay. Hold on. Enjoy the song as I do this. Here we go. Here we go. What's this? What is this? Here we are. I think we have a motion to quash. I think we have a motion to quash. Let's see. I'll let the song finish out as I get everything set up here. Let's this is the freshest of information. I'm gonna share the stream one more time to let people know. I'm tweeting it out live here. You guys signal boost this if you want. If not, that's fine. But yeah, this is the new stuff. I don't want people to leave just yet. All right. Here we go. Here we go. Oh, guys, this is real life. Real life soap opera drama happening in real time. Where else but the internet can this even happen? All right. The outro is almost done playing. Sorry to tease the exit. I know you were all just jonesing to get out of the stream, and I've left you with the bluest of testicles. The bluest of testicles. The Greek hero Testicles. Oh, speaking of which, FTM guy says Nick leaves the stream with the most azure of nuts. Mirage says, finally caught you live. Had to drop this. Keep up the good work, my guy. Thank you. And Sin says, got an interview tomorrow. Gonna listen in bed. Well, definitely get some sleep and good luck with your interview. Hope everything goes well for you. All right, let's hit these motion documents. Whoo, we've got some pages. We've got some pages. Oh my goodness. Buckle up, buckery boos. I'm going to go through these as fast as possible. All right, here we go. Vic Mignogna versus Funimation et al. Plaintiff's motion to quash and for entry of confidential and protective orders. The Honorable Judge of said court. Plaintiff requests that the notices of intention to take oral deposition of Vic Mignogna, the notice, be quashed and that the court enter confidentiality and protective orders. So now they're asking to quash Vic's deposition. They're motioning to quash Vic's deposition. So the background. On April 25th, 2019, prior to answering plaintiff's petition, defendants Toye and Rial served the notice without first conferring. So they did this on April 25th, by the way. First served the notice without first conferring on the date or time for the deposition. Notice is attached as Exhibit A. Plaintiff's counsel attempted to coordinate scheduling plaintiff's deposition and defendant's depositions. However, defendants refused to provide any dates for their depositions. See Exhibit B here too. Exasperated with defendants' contumacious refusal to cooperate. Contumacious? Oh, I love it. I love it. Plaintiff noticed defendants' depositions to occur on May 15th. Defendants promptly moved to quash these deposition notices. Plaintiff again requested that defendants provide dates for their depositions. See Exhibit C. Yet again, defendants refused to provide any dates for their depositions. See Exhibits D to E. In fact, nearly 2 weeks after being requested to provide dates, defendants have heretofore refused to provide any dates they are available to give deposition testimony. Further, anticipating that the depositions would delve into areas that are potentially sensitive or private for a party, plaintiff proposed that the parties into a mutually agreeable confidentiality and protective order, Exhibit C. Defendants not only rejected plaintiff's offer, but also made abundantly clear their intent to make deposition testimony, including sensitive or private information, public. Highlighted here. Frankly, I assumed Mr. Mignogna gave considerable thought to any personal privacy concerns before he filed his lawsuit. Regardless, my clients have considered his request and it is declined. Indeed, defendants prolifically post information on Twitter. Argument. So here's well, never mind. In general, a party may obtain discovery. So, well, okay, I'll talk about this. So how you do legal writing is something called the IRAC format. In a lot of places, it's introduction, rule, analysis or argument, and then conclusion. So we've got the intro with the background. The rule sometimes is included in the argument or analysis statement because it's right at the beginning. And the rule, it doesn't necessarily need its own subheader for usually 1 or 2 sentences, but that's what they're doing here. This is basic legal writing. This is what you write to a judge. Right? This is what you write to the court. In general, a party may obtain discovery regarding any matter that is not privileged and is relevant to the subject matter on the pending action, whether it relates to the claim or defense of the party seeking discovery or the claim or defense of any other party. Texas Rules of Civil Procedure 192.3. However, quote, trial courts should be mindful of protecting sensitive information, NRE Weekly Homes, NRE United Service Automobile Association. Thus, a trial court may issue orders limiting discovery where appropriate. Defendant's response to plaintiff's proposal of a confidentiality order is a thinly veiled threat of inquiring into private information during his deposition and posting that information to their Twitter accounts. Some of you who follow this situation closely, and I won't be talking about what it may be, but many of you who followed the situation or from the beginning or closely probably can guess at to what sensitive things they would want Vic to say in a recording and post publicly, right? Things that are not illegal, things that are not in any way related to workforce stuff, but just personal life stuff that they would want to use to smear in their own circles. I mean, they've been doing this. They've been doing this for years, and they've been really ramped up, of course, since the beginning of this year. So this would just be him saying it, which would be them shaming him, right? Their recalcitrance is short-sighted, as their own private information may be subject to inquiry during their depositions. Not wishing that any party, like, how long have you been a cuck? That's my first question. Not wishing that any party should be embarrassed by the public unveiling of sensitive information disclosed in a deposition, plaintiff respectfully asks his court to enter a confidentiality order governing discovery in this case and precluding disclosure of information that is confidential or private absent the court's permission. And plaintiff respectfully requests that the court quash the notice and enter a protective order that no depositions may be sought by any party until the court issues such confidentiality order. Wherefore, plaintiff respectfully requests that the court set this matter for a hearing, thereupon grant this motion, quash the notice, enter a protective order, and that no depositions may be taken until the court issues a confidentiality order and issues the confidentiality order requested above. Plaintiff prays for such other and further relief to which he may justly or be justly or equitably entitled. Plaintiff prays for general relief. So there you go. There you go. We've got FTM guy says nuts immediately shift from Azure to normal. Rick Nikita says, what did I miss? I just woke up. Oh, you missed a lot. Real Spider Phantom says 1.6k likes, 4.8k watching. Something's off. Something's off. Okay, let's get into these exhibits. Certificate of conference. A conference was held via written correspondence with Casey Eric, counsel for defendants Rial and Toye, on May 8th to 9th on the merits of this motion. A reasonable effort has been made to resolve the dispute without the necessity of court intervention, and the effort failed. Therefore, it is presented to the court for determination. So here we go. Exhibit A. Via e-service, April 25th. Mr. Beard encloses the defendant's notice of deposition and subpoena ducis tecum for the deposition of Victor Mignogna to occur on May 30th in your office. I am sure you appreciate the urgent need for this deposition in light of the pressing deadlines we are faced with, a possible motion to dismiss. I look forward to working with you to get this scheduled. All right. Very truly yours. photoshopped in signature. Oh, that's weird. Just put your signature in Adobe and have it. Whatever. Maybe he did. Maybe he did. Notice of intent to take oral deposition. Please take notice that defendants intend to take the oral deposition of plaintiff Victor Mignogna at 100 Independence Place. That's Beard Harris. Deposition will be videotaped. He's instructed to produce at the time and place of the taking of this deposition for use in conjunction with the taking of deposition all documents identified in the attached Exhibit A. Here you go. Documents to be produced. Notice these claims. All documents supporting any claims for damages. Okay. All communications about your claims made in this lawsuit. Okay. For someone whining about claims being vague and overbroad, have provided less, much more vague and much more overbroad document production requests here. All documents supporting your claim of defamation. I think you have a big chunk of them on your desk already, Casey. All documents supporting your claim of tortious interference. Yeah. All this stuff. Notice there's no time limit on any of this stuff. There's no specificity given to any of the parties involved. There's no reference. Never mind. It's just bickery stuff, which is annoying. All right, so this is Jim Bullock from Casey Eric to Ty Beard, CC Jim Bullock, Carrie Christie. When 8 a.m. came and went, I directed my staff to arrange for the court reporter and videographer, so they are set up for May 30th. If that now needs to change, then we need to leave May 31st and June 3rd open because your client depositions will be first before mine. Why? However, I am visiting with the clients to firm up dates for you. But for me to do that, I need your client to commit to May 30th or as close as possible to May 30th. I'm going to get you some dates, but I need you to promise me it's going to be this one so we can do ours after. There you go. Okay, so this is an email chain, and that's a response to this email from Ty. It says, hey, Casey, I had to deal with a serious emergency, so I wasn't able to confirm the deposition dates. Were you able to confirm the proposed dates for your clients? So there you go. Then we've got this. So that was April 26th. This is May 8th. This is from Ty to Casey Eric. Casey, 5 days ago, I asked you to give me availability dates to depose your clients. You failed to do so, so please provide me with availability dates for 2 days from May 15th through May 29th. In the alternative, please advise whether you will agree to a Rule 11 agreement to depose Mr. Mignogna first and to not file a motion to dismiss under the TCPA until we've the opportunity to depose your clients. Finally, will you agree to a confidentiality agreement in which your clients and Mr. Mignogna will agree to not publicly discuss any of the deposition testimony? I think this is in everyone's best interest since the matters discussed will be very personal for each deponent. If I don't hear from you by noon tomorrow, I will interpret your silence to mean that you will not provide the availability dates, that you do not agree to the proposed Rule 11 agreement, that you won't agree to a confidentiality agreement. In that case, we will file motions for a protective order and to quash the May 30 deposition of Mr. Mignogna. Please feel free to call me if you think we can work this out. That was yesterday, and instead we got the motions to quash. Then we've got this one. This is May 3rd from Ty to Casey. Hey, Casey, the subpoena Deuces Tukums were indeed inadvertently attached to the notices. Please disregard them. Your complaint about me not contacting you ahead of time is curious since you did not contact me before noticing Mr. Mignogna. My policy is to treat opposing counsel precisely as well as they treat me. I'll be happy to enter into a mutual gentleman's agreement to confer on these issues in the future. Personally, I'd prefer to be reasonable with opposing counsel as that tends to improve the outcomes for both sides. Regarding who goes first, I'm not aware of any rule that gives you the right to depose my client first. That said, I am willing to agree to let you depose Mr. Mignogna first, but only if you agree to not file a motion to dismiss under the TCPA until we've had the opportunity to depose your clients. My concern should be obvious. You could depose Mr. Mignogna and immediately file the motion to dismiss, which would trigger the discovery stay. Please let me know whether this is agreeable to you. If it isn't, please provide me with dates that are convenient to depose your client. Green Bullet Production says, Got a new job and I'm back on my feet. This for you and Vic's GoFundMe is next. I've been waiting weeks for the opportunity to do more than just share it. How embarrassing to be a cuck. Hey, thanks, buddy. I'm glad you're back on your feet. That is fantastic. Hopefully things continue to go well for you. All right, so then we've got Exhibit D. This is via e-service and email. This is May 9th. Oh, so this is the letter. This is the letter that that Ty's letter was responding to, it appears. It appears. Altira Mungara, looking forward to seeing you at Anime Matsuri. Hey, back at you. Make sure you introduce yourself, please. Bamboo Shoot says, Vic is truly blessed for he has found Zeus himself. Cherish Willis says, news on Marky and her lawyer in deposition. I don't have any. I don't have any. So there you go. Let's go. All right, so this is Casey's letter. Mr. Beard, yesterday, Wednesday, May 8th, you sent an email and identical facts demanding I immediately respond to various issues by noon today. In doing so, I will necessarily need to correct several misstatements you have made in your correspondence. In that regard, I turn to the following. Thursday, April 25th, I e-served a cover letter and deposition notice with a request for documents for Mr. Manana's deposition to occur on May 30th in your Tyler, Texas office. I explained the reason I included the deposition notice and at the same time stated I would work with you to schedule the deposition. Okay, I didn't see a misstatement on that. On Thursday, April 25th, 2:57 p.m., your email acknowledged receipt of deposition notice and request for documents and stated, I receive your notices for depositions. I think that May 30th is fine with us. I need to confirm one item, though. If you don't hear from me by 8 a.m. tomorrow, assume that we're good. I would also like to depose Monica Rial on 5/31 at your office and Ron on 6/3 at your office. Are those dates good for you and your clients? On Friday, April 26th, 5:11 p.m., your email stated, hey, Casey, I had to deal with a serious emergency, so I wasn't able to confirm the deposition dates. Were you able to confirm the proposed dates for your clients? Friday, April 26th, 5:26, I responded with, when 8 came and went, I directed my staff to arrange for the court reporter and videographer set up for May 30th. If that needs to change, then we need to leave May 31st and June 3rd open because your client's deposition will be first before mine. However, I'm visiting with the clients to firm up dates for you. But for me to do that, I need your client to commit to May 30th or as close as possible to May 30th. On Thursday, May 2nd, your email stated May 30th is fine for Mr. Manana's deposition. We can't do June 3rd and 4th, so I'll find other dates. On May 3rd, you unilaterally served deposition notices and document requests for my clients and scheduled them to occur on May 15th in your Tyler, Texas office. Nothing wrong with that. Nothing wrong with that. Friday, May 3rd, I responded with, Mr. Beard, I received the deposition notices just now for Monica Rial and Ron Toye to occur on May 15th. Maybe I am confused, but you heard me say we will depose Mr. Manana first. Maybe I'm confused, but you heard me. No, you're not confused. You're not confused. You can hear someone say it all day. And in your last email, you indicated that you were going to review your calendar and advise of other possible dates after June 3rd or 4th. Is that what he said? No. Nope. You are confused on that one, Casey. I'll find other dates. Now, despite these recent emails to each other, you unilaterally noticed my client's depositions for May 15th without once asking whether we were available. I mean, he's been asking you for dates. You didn't provide any. We are not. I have a deposition that day in a matter pending in Dallas District Court, and my clients are not available either. I am also confused why you include the request for documents knowing you did not allow 30 days to respond, which he withdrew. Even if we could appear for deposition on the 15th, well, he probably withdraws it in response to this, which we cannot. I would not provide documents as the requests are untimely and served in violation of the rules. I'd like to continue working with each other and we'll assume this was an oversight by your office. In that spirit, I kindly ask you to withdraw your notices of depositions. If not, I will file the appropriate motion with the court on Monday. So on Friday, your email said, hey, Casey, the subpoena deuces tugums were indeed inadvertently attached to notices. Please disregard them. Your complaint about me not contacting you is curious since you did not contact me. Blah, blah, blah. We read this. On Tuesday, May 7th, having not received a response to my request to withdraw the deposition notices. I mean, you did receive a response. You just chose to not respond to it, apparently. let's see. I mean, it specifically says willing to agree to let you depose, but only if you agree not to file the motion. So he did respond. There's just, I guess it wasn't explicit enough. Let's see. Anyway, I was forced, having not received a response, I was forced to file a motion to quash and motion for a protective order, in addition to preparing objections to the 44 document requests you claimed were mistakenly included. But he withdrew them. He says they're withdrawn. For obvious reasons, without an executed Rule 11 agreement, I can't rely on your comment to disregard them. Oh, I mean, yes, you can. God, that's just... Still in our motion, I requested you provide dates after June 3rd or June 4th, as indicated in your May 2nd email above. Well, which you misread, because it doesn't say after. Your email stated, Casey, 5 days ago, I asked you to give me availability dates to depose your clients. You have failed to do so, so please provide me with availability dates for 2 days from May 15th through May 29th. In the alternative, please advise whether you will agree to a Rule 11 agreement to depose Mr. Mignogna first and not file a motion to dismiss under TCPA until we've the opportunity to depose your clients. Finally, will you agree to the confidentiality agreement in which your clients and Mr. Mignogna will agree not to publicly discuss any of the deposition testimony? I think this is in everyone's best interest, since the matters discussed will be very personal for each deponent. If I don't hear from you by noon tomorrow, I will interpret your silence to mean you will not provide the availability dates, that you do not agree to the blah, blah, blah. Please feel free to call me if you think we can work this out. Failure to confer for depositions. I believe it is now clear that I did confer with you about your client's availability, and you agreed twice to the May 30 deposition. On April 25th, I did ask for Mr. Mignogna's deposition on May 30th to occur in your office, and the accompanying document requests were served in compliance with Texas Rules of Civil Procedure. That same day, you agreed to this date, and actually, that's not true. Not technically true, and said to move forward with scheduling if I did not hear from you by 8 a.m. the following day. Because I did not hear from you, I scheduled the deposition. Next day, you claimed there was an emergency that prevented confirmation and asked for my client's availability. We would wait for you to confirm a new date and leave May 31st and June 3rd open if Mr. Mignogna's deposition needed to be rescheduled. I added that Mr. Mignogna needed to commit to May 30th or a date as close as possible to May 30th before we would know what alternative dates would be open for my clients. I did not hear from you until May 2nd, and because the deadline to automatically stay the deposition by motion had passed, understandably assumed May 30th was confirmed. Even so, on May 2nd, you confirmed May 30th for Mr. Mignogna's deposition and advised June 3rd and 4th were still not available for you to take my client's depositions. You said you would find new dates. Still have not provided alternative dates after June 3rd or 4th on which you want to depose my clients, which he doesn't have to. He noticed you on alternative dates before. The next day, I received deposition notices from my clients to occur on May 15th in Tyler, Texas. You did not ever mention May 15th as a possible date. First I heard of this was when I read the deposition notices, after which I informed you I had previously scheduled depositions on that day. Despite failing to confer and knowing of my conflict, you did not withdraw the notices, which forced the filings of the motion to quash and protective orders and caused my clients to incur completely unnecessary attorney's fees and expenses. No, I think you did that. Agreement to postpone TCPA motion until plaintiff has had the opportunity to depose defendants. Here we go. For obvious reasons, we cannot agree to an open-ended postponement of our TCPA filing deadline. Why not? Why not? The court can extend the TCPA filing deadline for all sorts of reasons. They did it in Meyer versus Wade. And certainly counsel can agree to extend the TCPA filing deadline. There is zero problem with this. Zero problem. It's broadly applicable within the rules, and that broad applicability would apply to two attorneys agreeing to extend the deadline under a Rule 11 agreement. A party seeking the TCPA protections must comply with these requirements. Braun versus Gordon. Not later than the 60th day after the date of service of the legal action, the court may extend the deadline. Oh, wait, yeah. Service of legal action. Next one. Court may extend the deadline upon a showing of good cause by the movement, which is, we have agreement. That's good cause. There's not yet been an opinion interpreting what is required for good cause under this provision. I mean, under Meyer versus Wade, it was obviously granted as just an agreement between the parties based on jurisdictional discovery. If jurisdictional discovery is enough to stay it, then certainly a few days for another deposition to be taken is enough to stay it. It is within the trial court's discretion. Open questions also remain about whether the motion filing deadline can be told, stayed, or abated by the application of other procedural rules or statutes. Such an agreement is not possible given the strict deadlines in the TCPA and his client. They're not strict. They're not strict at all, actually. This is completely either ill-researched or disingenuous. TCPA can be extended for plenty of reasons, and certainly, Casey, you're not like lying here. You're just dumb, right? Certainly, the parties agreeing to the extension of the TCPA, the people who would be affected most by the TCPA agreeing to an extension is good cause and within the trial court's discretion. Absolutely. Absolutely. That's a disingenuous line, you nice person. Vic Mignogna's request for a confidentiality agreement. In all candor, Mr. Mignogna's request for a confidentiality agreement was surprising. First, the request seems to be a last-minute add-on as it wasn't mentioned before yesterday. As if that matters. Frankly, I assumed he gave considerable thought to any personal privacy concerns before he filed his lawsuit. Regardless, my clients have considered his request, and it is declined. Okay. Ty, I took the time to give you a detailed response so that you and I are clear on how we got to this point. To be certain, I do not believe a motion for protective order could be filed in good faith and not viewed as discovery abuse. My clients have already incurred considerable expense and time to schedule the deposition of your client, which began exactly 2 weeks ago today. What expense to schedule a deposition? What expense? What considerable time and expense was it to pick a date on a calendar and to have your secretary call 2 people to see if they were available that day? What expense? Even now, considerable time was spent responding to these last-minute antics and erratic proposals with only a few hours' notice. Hopefully, we can avoid this in the future. Very truly yours, Casey Eric. And then, of course, here's a letter from Ty that we just read. There you go. There you go. That's how we got to where we are. That's how we got to where we are. Trial subpoenas, I believe, will be filed. Trial subpoenas filed in the morning. If I have time and they're worth talking about, I will go ahead and do that. I will go ahead and read them. I don't know if I'll be able to. Got a couple last chats, and then I'm going to shut the stream down. Make sure you go check out Tug's live stream in, I believe, 25 minutes. Okay. We got Eagle Stalin says, FYI, Monica is in Atlanta, Georgia for a convention May 23rd through May 26th, 2019. So she presumably won't be allowed. Oh, I guess I could go ahead and start the outro again. Here we go. Alucard SRH says they are fearing the beard and show Vic innocent. Snubbirth13 says, would they be stalling hoping that Vic would run out of funds to continue at some point? No, that's a bad game. Vic has a $150,000 advantage for that. So that'd be a stupid tactical move. Maybe they are. I say stupid tactical move and immediately realize who these people are. But no, most likely they're stalling for the TCPA. That's what they're trying to do. And of course, here's the great riddle, right? For the TCPA, they could actually just file it now. They could file a TCPA tomorrow, probably defeat this motion, probably defeat any trial subpoenas because it's a discovery issue and discovery would have a mandatory 90-day stay imposed by the TCPA. Casey Eric could file his TCPA motion already. He could have filed it already, but he didn't. Instead, he waited till the last minute to file Vic's deposition. And let's see what let me see this. What do we got? Yeah, so he files the notice of deposition, sets it for May 30th. let's see. Let's count the days on the calendar here real quick. The initial thing was on the 18th. Let's see. 7, 14, 21, 28. Oh gosh, 35. And then he sets his date 42 days out, leaving a short window for to give the illusion that because yeah, we're at what, 47, wait, 40, we're 42 days on the 30th. So then that would leave, in theory, 18 days for them to not be available for a whatchamacallit, a follow-up deposition from Monica and Ron. However, even if they scheduled them and then filed the TCPA, it would stay those depositions anyway. So clearly the plan, it's absolutely bogus. The fact that they wouldn't agree to a Rule 11 agreement to extend the TCPA or to go ahead and do the depositions prior to filing a TCPA is a complete telegraphing of the plan. So it's just stupid. Okay, finally, Alucard SRH says they fear the beard. Oh wait, I read that one. Kaki Onsai says KZ Eric is all hat, no cattle. And FTM guy says, couldn't Tile just file a quash saying object to form? Nah, only works in the depositions. All right, guys, I'm gonna close out the stream. Thank you all for joining me tonight or today. I'll see you tonight at 11. Go check out Tug's thing. Check out Tug's book. Have a good night. Peace.